Kambwe and Kenke, Prof. Kenenge. One night, the very son of the brave general of the Biafra Army. Welcome to Alebo. The legality of the action taken by the Nigerian government in September last year in proscribing IPOB and the sustenance of that action by Justice Kafrati in February this year pursuant to a motion to vacate. Onye na good news gama na federal government through the Attorney General approached the Federal High Court to declare IPOB a terrorist organization standing on an ex parte application. Onye na awu lawyer mana onye anoho nso anaghị amụ ya ikpe. Lawyers na akpe ọdị ọtrem patem. Ikpe anaghị ebi n'olu ofu onye. Mana nke a ebiri n'olu ofu onye n'olu federal government dịka ihe file na court. So based on otu o si wee gaa, we decided na I ga approach the court. Ka akọwatụrụ ha na ihe a dị very serious and perhaps IPOB should have been put on notice. Wede magonu ode Nigeria nọ ya kita. Ihe ga kurusiwega the acting chief judge Joe. So I single-handedly took the matter before the African Commission on Human and People's Rights in Banjul, the Gambia. One, the proscription and declaring IPOB a terrorist organization. Then the second one was self-determination. The greatest argument go a levy against self-determination. Referendum a garden variety expression of self-determination, and so on and so forth. The greatest argument is quite simplistic, but it seems to win the day. That self-determination is unconstitutional. Not because the Constitution declared it so, but because it was not recognized by the Constitution through any express provision for it. Okay, fine, well and good. But what about the other laws of Federation of Nigeria? Or no legal argument, and a political argument in support of self-determination. And when any law that was promulgated by the British, upon which the referendum that exercised part of Cameroon from Nigeria was conducted, it was a political arrangement. There is no particular section in the 1960 or 59, 60 or 63 Constitution that guaranteed the creation of Midwest region. But it was done through a plebiscite. Plebiscite or a word of art for referendum. Anyways, putting the political justification for self-determination aside and the historical precedents, Mmadụweke site, Ebo Mego, Alabawaro, and where legal justification for it in Nigeria, already recognized. Prior to perhaps 2, 3, 4, 5 weeks ago, much of the citation, any proponent of self-determination, they make about the African Charter on Human and People's Rights. Then they go on to the UN Charter. Then they go on to other protocols like ECOWAS, treaty obligations. Fine. That argument easily can also be shut down. Because under Section 12 of Nigerian Constitution, Nigeria does not have to implement any treaty if it doesn't want to. It is true that the National Assembly can ratify a treaty, but the government can say, well, we are not going to implement this treaty because it's against the laws of Federation of Nigeria. But guess what? There is one particular treaty that is no longer a treaty in Nigeria. And with a total misconception, because that African Charter on Human and People's Rights, as far as that charter or provisions thereof applies in Nigeria or brought a treaty or law, what part of the laws of Federation of Nigeria, enacted by a National Assembly, ratified, then enacted. And when any other foreign treaty, when it the same tenor, is part of our organic law. Enact. If you go to Laws of Federation of Nigeria, as officially published 2004, you will find a law called the African Charter on Human and People's Rights, bracket, Ratification and Enforcement Act, Laws of Federation of Nigeria, Chapter 9. And when any other treaty like that, it's not a treaty, it's our law. Section 20 of that law. Before I'm there from Washington, the previous lawyers, both in the public fora and in court, stopped their arguments short of not a treaty. But it's not. I'm expert in international law by the grace of God. I'm saying about a treaty. So this argument, not before the Federal High Court in Abuja now, it is a new argument, and based on that, I have filed a flurry of motions and applications to dismiss all the pending charges against IPOB members in any part of the Nigerian court. Because Section 20 of that law, I can paraphrase it for you, say that all people shall have the unhindered right to self-determination. Section 20 of Nigerian law said that any lawyer here can check it out. A non-lawyer can also, pursuant to very good research, can also check it out. Then Section 1 makes it binding on the Nigerian state not to disturb that right to self-determination. So, as interpreted by the African Commission on Human and People's Rights, these two sections were part of Laws of Federation of Nigeria, even though, thank you, even though they were counterpart sections, now the charter that binds all of Africa, and of course, they were counterpart sections, now the UN charter that binds the rest of the world. So, don't allow anybody to tell you that the recognition of the right of self-determination in the African Charter and UN Charter were mere force of customary international law. In other words, now they use those sections to persuade nations to let my people go, but you cannot enforce. We, as Nigerians, we have a section that backs us up. So, the Commission addressed a letter directly to the President of Nigeria, or the lengthy 6 pages. They pointed out a whole lot of violations and gave him 15 days to do certain things. One of them being to end what I believe and I characterize as persecution, not prosecution. As we speak, I'm waiting for a response from the Commission as to what the President might have done to call his troops home. Because if the right thing is done, he's supposed to issue directives to the Attorney General to cease and desist from further prosecution of IPOB members or anybody that as much says he believes in IPOB. Then the final point I'll make is this. To the young people here, I believe in that. Ona ademma emayago akanono. Mako weke tagi. Monkitara, amamma agu kainiana, monkitara kainiana. Monkitara. Amoequerenkitara akanono. As we speak, 2 weeks ago, 3 youth, not the lazy type according to our president, hard-working youths of Igbo land, they arrested na Newi because Haji flag Biafra Hagara Ulu Akwa na Aguleri na Alota with flag of Biafra but amba na Aguegu na Alo na Kosamba. I may have cost based on tip-off. So her disperser HD 3 charge her before the Federal High Court Noka. So luckily I'm on my round. So I entered appearance. I named the charge sheet. Gave her emego arraignment. Year case 30th of this month. In here the idea that na ejidere in possession of IPOB flag. Therefore, now a member of a proscribed organization under the Terrorism Prevention Act of 2011. Fine. So, I asked for the proof of evidence, and I got it. In fact, I met with the Commissioner of Police. He was kind enough, Mr. Omar, he go see phone here, or my video. I a video flag and the Biafra, or flag and the IPOB. Yes, and when he had each. So on 30th, the case might be dismissed, and this is going to be the argument for the young people now. Biafra is not a proscribed organization. IPOB is a proscribed organization. So, Kaiweru Akonu Chenaga. You engage in Nigeria. You engage Nigeria on that platform for now. The judge is agreeing with us. Flag Biafra Kahaji or IPOB. The order from the federal court declare it targeted an organization. And even that prescription itself is a matter before the Court of Appeal. We have filed a motion to stay the execution of that order. But we're not depending on that because sometimes if you wait for the judiciary, it might be too late for you. So the advisory there, anybody that is saying anything can say it under the umbrella of Biafra. I'm addressing the few IPOB members that are here because I'm sure you are here. Don't be caught pants down with IPOB flag, but you can carry Biafran flag, you can wear the armband or nothing. It was never the organization that was proscribed. So, because ADF